Hi, I'm Jessica Eaves Mathews. If you're a founder, there's a particular email that can stop your heart for a second. You open your inbox, and there it is, a cease and desist letter. It might be from a law firm you've never heard of. It might be from another business owner. It might even be aggressive, threatening, or confusing. And your brain immediately goes to worst case scenarios. Do I have to shut down? Am I about to get sued? Did I build something I'm going to lose? Today, I want to talk about what founders should actually do when they receive a cease and desist letter, and just as importantly, what not to do. Because how you respond in this moment can either protect your business or make things much worse. The first thing you need to know is this: not all cease and desist letters are equal. Some are sent by companies with strong trademark rights and real legal leverage. Others are sent by parties who don't actually have priority, don't have a valid trademark, or are trying to scare you into backing down. And you cannot tell which is which just by how aggressive the letter sounds. That's why the worst possible first reaction is panic. The second worst reaction is ignoring it. And one of the most dangerous reactions is responding emotionally or too quickly. I've seen founders reply with long emails explaining their entire business history, admitting dates of use, or promising changes that they didn't need to make. I've also seen founders fire back angry responses that escalated a situation unnecessarily. Both approaches can lock you into a bad legal position and run up your costs. What should you do? The first step is to pause and assess. You need to understand who's making the claim and what rights they're actually asserting. Are they relying on a registered trademark, or do they have a pending trademark application? Or is their use just based in common law rights? Then you need to look at priority. Who used the mark first and in what context? This is where the dates of first use matter. A registration does not automatically mean the sender has superior rights. You may have the superior rights even if they have a registered trademark. You also need to evaluate the strength of both marks. Are the marks actually similar in a trademark sense? Are the goods or services related? Are customers likely to be confused between the two marks? These are legal questions, not gut feelings. And here's something founders don't often realize. You do not always need to win a cease and desist dispute to protect your business. Sometimes the smartest outcome is coexistence. Sometimes it's a narrow agreement about how marks are used. And sometimes, yes, it is rebranding, but done on your timeline and not under pressure. A trademark lawyer's job in this moment is not to escalate, it's to give you options. I worked with a founder who received a cease and desist letter that looked terrifying at first glance. But once we analyzed it, we realized the sender's rights were limited geographically and did not cover the founder's services. So we responded strategically, and the matter resolved without litigation, without a rebrand, and without ongoing risk. That outcome only happened because the founder did not respond impulsively. Let me be clear about common mistakes to avoid. Do not ignore the letter and hope it goes away. Do not respond emotionally or defensively. Do not admit facts or promise changes before understanding your rights. And do not assume that the loudest voice has the strongest legal position. This is one of those moments where having a trademark lawyer is not about being aggressive, it's about being protected and strategic. A good trademark lawyer helps you evaluate the risk, decide whether and how to respond, and position you to protect your brand, whether the dispute ends quickly or continues. If you're listening to this and you've already received a cease and desist letter, or you're worried you might have one coming, here's my advice. Before you respond to anyone, get clarity. Understand your priority, understand the strength of your mark, understand your options. This is exactly the kind of situation where a consult with a good trademark lawyer can save you from making a very expensive mistake. If you want help evaluating a cease and desist letter or figuring out the best next step for your specific situation, that's the kind of work that I do every day. You don't need to navigate this alone, and you don't need to panic to take it seriously. Just set up a call with me and let's talk, and we'll figure a way through it calmly and strategically.